co-conspirator statements, as well as all of the other evidence that y'all, the state, intend to introduce with the next several witnesses, has been provided now in detail. So I would propose that that's where we start, unless somebody thinks something else would be more efficient. That work for everybody?
Go salute to everybody and hey, good morning. I appreciate y'all for rocking.
Okay.
Good afternoon too. We here. I held it down, y'all.
Been able to get together on any of it to come to agreement on anything, or are we going to litigate all of it?
Your Honor,
Yeah.
for clarity, are we discussing the evidence that was shared by Mr. Atkins on Friday night? Is that?
I mean, I think there have been a couple of different shares. There was, and I also don't, off the top of my head, know exactly when. There was one, and then there was the supplement, and then there's also, I think, something that Ms. Hilton shared that's in a spreadsheet, which I think covers the same things that Mr. Atkins provided already.
So I think there's multiple, God bless you, there's multiple things.
Yes.
We sent the evidence regarding upcoming witnesses a few weeks ago, according to Mr. Atkins. What we sent on Friday, Your Honor, was the co-conspirator statements, making sure that the ones that the state intends to use were provided. And then yesterday, what I did was I provided a spreadsheet of the co-conspirator statements that are found within Mr. Garlington's wiretap, which had already been provided, and Mr. Sumlin's wiretap that had already been provided.
Okay.
So I just specified which statements from those wiretaps we intended to use.
Okay, so that's a subset of the bigger set.
Yes,
so,
sure.
I mean, we can start there if y'all want to start there, or are those going to come in later in the trial?
Most of those are going to come in later in the
Okay,
trial.
well then we'll set those aside for now.
And we submitted the 31 through 60 witnesses.
Right.
Oh, I'm sorry. We submitted the 1 through 30 witnesses on August 8th, 2024.
Okay.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one, and I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay, so yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Your Honor, on
Yes.
behalf of Mr. Ryan, and what was received on Friday, I think was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions in limine, the basic ones of this is inadmissible hearsay, those types of items based on what we just received. I don't know if those are the immediate upcoming witnesses. We're going to prepare as fast as we can. We're just kind of, getting the rolling. This is what's actually being introduced.
And so we, in my speaking with Mr. Williams, I did let her know that if she had specific objections, there may be things that we could agree to. She did name some, and I agreed with her. So we were continuing to discuss those. So if after those conversations, Ms. Abbasi and Mr. Williams feel like there's still more to litigate, that'll happen. But that conversation, that dialogue has started regarding those things that have been turned over to Mr. Ryan.
I think what probably would be the most productive is things that we have issues on, we make note of and make a record. This is the defense raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. So we'll get Ms. Love to do that.
That's fine.
We'll
That's
get
fine.
that to the court as soon as possible. I don't know if they are in the next few witnesses category or not.
I mean, I don't either right offhand, but if it is, we're litigating that stuff this week.
Right. Did the state provide a little bit of guidance?
No, Your Honor, the stuff for the Jamari Holmes are not within the next 10 weeks.
Okay.
Oh, thank you.
All right. That works.
Plan ahead, thank you.
How about Mr. Kendrick's statement that there's the Bruton issues on, right? And when's that going to get introduced?
So not in the next 4 weeks, actually, based on who it is that we intend to come before the witness that would introduce.
Okay. What witness will that be with?
Investigator Thor.
Well, y'all got him listed as witness number 5.
We do, but he has had he will be moved down based on some circumstances that have occurred in his.
Oh yeah.
Okay.
Spandex.
He has some personal matters.
Okay. So is it still going to be Burnett, Sledge, Zachary, Dean, Morton, Sprinkle, the phone custodians, Bernie, generally?
Generally, yes.
Okay. And then I guess Thorpe will be at the end of those now? Okay. And that PowerPoint, that's
with Dennis.
That's with Dennis. Okay. So he's several out. Okay. All right, so great. That'll give y'all some time to get together on that statement to sort Bruton issues. Mr. Steele, you also seemed to kind of be making a broad argument that nothing in his statement, in Mr. Kendrick's statement, even if it doesn't directly implicate your client standing alone, needs to be redacted, or there needs to be a limiting instruction about that. Do you have any law to back that up?
I'm trying to get proper law, but in this case, there has been over objection the announcement that YSL is a criminal street gang that Mr. Williams, according to 3 supposed experts, is a member of, in addition to Trintavia Stevens, said that Mr. Williams is a member of, in addition to Mr. Walter Murphy, had Mr. Williams allegedly as a member of. There may be others. And then in Mr. Kendrick's statement to law enforcement on October 6th, 2015, he discusses YSL, the crew, the gang. So I think that under Bruton, it's an element of the offense of criminal street gang as well as RICO that I believe that does not indirectly but directly implicates Mr. Williams. But I'm looking for law on that. But that I do not want to waive that issue. In addition.
Well, yeah, just get me some law and we'll take it. Sounds like it's not quite as time sensitive as we thought it was, but we still need to get moving on it. So try to get me the law that would cover that.
In addition, I'm sorry.
Go ahead.
No.
Go ahead, I'm done.
Thought this on before stuff. Yes, I do want a limiting instruction, and that comes right out of the cases that I did cite, because that statement I cannot cross-examine. Mr. Adams cannot cross-examine Mr. Kendrick. That statement should be his alone. And it's a confrontation clause, so it does not move the conspiracy forward. So it's not a recognized exception.
Okay.
So the second part of the question was, do you have law for the limiting instruction? And I already provided, but I could provide more.
Okay. And then I do want you to get with the state to try to come to an agreement as to what needs to get redacted to avoid Bruton, at least the classic Bruton issues, and we'll have to take up whether any kind of talk whatsoever about YSL gets included within that or not. But as to sort of the classic, Mr. Williams did this, which I doubt if he says something like that anyway, but something that would directly implicate your client standing alone. Y'all the state ought to know what that would be and be able to redact that out. And it's going to be played as a video statement, right? So, right or no?
We intended to ask questions.
Okay.
Versus.
That's fine. That's fine.
And Your Honor,
Yeah.
I did that in my motion. I was specific, and I get the timestamp where it starts. And I did it not only for Mr. Williams, but I did it for anybody else that I saw. And I did it for Shannon Stillwell. He's mentioned a great deal as well. So I believe that I flagged. If I missed anything, obviously, I'd like somebody to tell me. But I believe I've already done it. If the state agrees with it, then we need to figure out, make sure that the witness or witnesses know.
Sure.
But other than that, that's been done, Your Honor.
Okay. Thank you.
Hey, Your Honor.
Yes.
While we're on this topic, just an additional issue. Not only are there Bruton matters, but there's also just typical evidentiary rule matters, such as speculation. At one point, Mr. Kendrick is asked who he thinks may have done this, for instance, and he names some names. That's the sort of thing that would need to come out, Bruton or not, if we're asking about speculation.
Okay, well, it sounds like it's not going to be played as sort of a running statement. It's going to be more targeted questions to the, I guess, investigator that conducted the interview.
Correct.
Okay,
So that would not even be an issue, putting in or trying to redact out.
Okay.
Those kind of comments.
All right, good. All right, so let's turn to some of the specific then evidence that's going to be coming in with these next witnesses. So there's not anything controversial with regard to witness Burnett's evidence, right?
Tap the like button, subscribe to the channel. I appreciate you being here. Mwah.
And everybody else is silent, so I'm going to take that as a no for everybody else. All right, so Mr. Sledge, there are some co-conspirator statements from him. We already did his interview, right?
Right.
Okay. Did we do his jail calls, or do we still need to do that? Maybe I can look at the more detailed exhibit list that y'all provided to everybody.
Your Honor,
Yeah.
before we discuss the jail phone calls, I do have one possible issue. I'm not sure how the state plans on doing this. I see the fifth row down on Mr. Burnett, comparison photo infinity Q5 or Q50 and gas station still photograph. I don't know exactly what that means or how the state anticipates that presentation to go in court. I don't know what Mr. Burnett's qualifications would be to compare two photos. So I'm just wondering how the state anticipates that playing out in court.
Okay. So are you looking at the first 30 witness list? Is that what you're looking at?
I believe I'm looking at the same thing as you. It starts with 81 and then Copeland under the witness.
No, I think you've got a more detailed one than I do. I need to find a more detailed one. That was a Dropbox link, right?
Correct, Your Honor. And in regards to what Mr. Shard is addressing, Mr. Burnett, both back in, I forget the exact date, but during Deputy Sprinkle's investigation, he worked at an Infiniti dealership. He's worked for Infiniti for over 20 years, so it's lay opinion testimony. Obviously, the state has to lay the proper foundation when he's on the stand, but his ability to recognize Infiniti vehicles is through his 20 years, and he personally has driven Infiniti cars. So obviously that has to come out, but it's not scientific expertise.
He's an expert because he's got all kinds of daily experience with it from the last 20 years or
Yes,
whatever.
sure.
Okay. Okay. So does that answer your question, Mr. Sharp?
It does. So I guess Mr. Atkins, you are going to ask him in front of the jury to compare the two photos and testify whether they're the same type of car. Is that
Correct, Mr. Sharp.
okay?
As one piece of his testimony, I mean, essentially, after the foundation is laid, he will use his lay opinion as a 20-year Infinity rep to state his opinion of what specific vehicles are in both exhibits admitted and demonstrative photos that are included in that Dropbox link.
I don't know. I would like the sound of the court to look at the photographs. I don't know if we need a individual lay person to say that these are similar.
Do I have, I mean, you, Mr. Atkins, are saying lay, but then you're describing something that I would think if this is beyond the ken of the average juror, it's expert, even if it's based on his 20 years as an Infinity rep. So which is it?
So, Your Honor, he can be, his experience as an Infinity rep, if he needs to be deemed an expert to state what the vehicle is in specific photographs, it's all through his training and experience of working with Infinity's hands-on for 20 years.
Okay, well, that would probably then be expert, but do you want to show me what it is that y'all are, I mean, I see that one of the things listed is comparison photo, Infinity Q50 and gas station still photograph. Is that what you want me to look at, Mr. Steele?
And Your Honor, some of these exhibits, so there's the exhibit of the drive-by shooting that resulted in Mr. Thomas's death that is at nighttime. And there's also a lit up, the Texaco gas station that's like 50 feet from the crime scene location. So that Infinity vehicle, in the state's belief, is the same vehicle seen in the kind of more lit up gas station and also the vehicle that did the drive-by shooting. And so it is not as easy for just a juror to decide, because of the quality of this 2015 surveillance video, what kind of car that is driving down in the...
Exactly, because that footage trash. So how, since he an expert, he gonna be able to look at the same footage and determine that that is what y'all saying it is? That's cap. That's cap. His explanation just debunked himself. He said the jury can't look at the footage, but some guy, just because he a professional, can look at the same low-quality footage, though. The image not changing. So how all of a sudden he remarkably got better eyes? We all got 20/20 in here, or human eyesight. Now all of a sudden, because he work at Infinity, he can see through the footage better. That's crazy.
Okay.
Either of these.
So are you going to have Mr. Burnett look at the darker, more grainy drive-by and say, I can identify this as an Infinity because of X, Y, and Z things?
She's saying that in a condescending tone because she's alluding to the same thing as me. So you ready to have him look at the same blurry footage. And because he's an expert, y'all see that? She was condescending too. She was actually a little bit worse than me. I don't know if she noticed it.
Correct, John.
Okay. And then you're going to have him...
Okay. And then you're gonna... Yo, she trolling them, y'all.
Look at the same thing in the gas station photo and say, in my opinion, this is the same Infinity because of X, Y, and Z things?
He will say...
Yo, respectfully, she shouldn't be allowed to allude to them. You sound like you on some bull. She being a little bit biased, y'all, in the defense.
He will speak about the make and model of the
Okay.
vehicle. He won't be able to definitively say that's the exact same car.
But you anticipate he'll be able to say, this is the same make and model as the one shown in here, and here's how I know that, here's how I'm able to determine that?
Correct, Your Honor.
Okay. I mean, that seems legitimate. And then obviously
What?
the jury will be instructed they can believe it or not believe it, but that.
All right. Here we go with this thing with the judge saying for the jury to believe it or not believe it. I'm confused on a judge being willing to let the state present evidence that's not supposed to be a fact. Like, I'm tripping. We could just float stuff up here and see if they believe it. I'm confused about that. That's tricky. If that's the case, we might as well just throw guys up here and just sling. It's a numbers game. How many times can you manipulate the jury?
Seems okay. Okay. All right. So then we have Mr. Sledge and his jail call. Did we already do his jail call?
We haven't. I've listened to the jail call. I would object to the jail call. It's Mr. Sledge talking to his fiance or wife about what happened in court, and it's definitely
That's
not
a relevance objection.
It's not relevant. It's speculation. It's definitely not furthering any conspiracy. I'm not sure why that would be admissible.
Okay.
We would not play that jail call unless there was something that Mr. Sledge said on the stand that contradicts something that he said in the jail call.
Okay.
So,
that's just potential impeachment. That's
right.
not going to come in during his.
Right.
Okay.
Right.
All right. Well, I mean, it's still out there as impeachment if that becomes an issue, but we won't. Yeah, it sounds like they agree. Okay, and is that it for Mr. Sledge? We already did his interview, so that's the only jail call.
Right.
Okay. All right, so then Mr. Zachary, and we've done both of his statements already. Jail calls and social media. Yes.
Is there an updated, can I ask the court to inquire whether there's an updated contact or address or both for Mr. Zachary? Somebody said that he's in North Carolina. I don't have any contact with that.
Okay, can you provide, if his contact information has changed since y'all last provided it to the defense, can y'all provide updated?
So the last time before last that we spoke with him, someone indicated that he was, but it appears that he is still in
the same place he was. Okay. All right.
The last week, just for you to know if it matters to the court. Hold on, can I ask this question? We were told that he's very ill. That's what I was told from the detectives.
Okay.
And I was told that he's in a hospital. That was dated June 4th, 2024. So we haven't bothered him at all. But if that has changed.
In a hospital?
The state said it's,
For what?
it's
Okay.
We can discuss that aspect of him.
What are you in the hospital for?
At the bench or something like that. I don't want to put personal information about anybody out.
No, I agree. Is that something we need to come up now and discuss?
We can.
Okay, let's do that.
Yo, let me know in the comments. What are you in the hospital for?
How he perceives them as a group. He is associating himself with them. He's saying they dirty.
Okay, well, so the check remains part remains unexplained, but
I don't know
What?
Mr. Zachary proclaiming all my dogs dirty would have anything to do with this case.
yeah, well, I mean, it might make something more
What?
primitive than it
Who is
more likely than it
dogs?
would be without. So I'm going to overrule.
Lady. So what you saying? Who is dogs? You really ready to take that metaphor and insinuate that he really talking about something incriminating and it's worthy to be brought up as evidence in front of a jury? That's cap. all my dogs is dirty. Better check for mains. Y'all ain't even slick enough with the English language in the way hip hop lyrics and urban vernacular and lingo work to try to say that that can be used in court without reasonable doubt that that's trash and it shouldn't be brought in under the strength of goddamn freedom of speech, like a metaphor. And you gonna really try to, man, that's cap right there, y'all. I'm gonna have to say, that's cap.
Video, someone else who's not charged, who's cussing and pointing guns, and they, I think they say YSL in the video, that at this point, any probative value derived from playing this video at this point in this trial, after all the other videos that have been played, is marginal at best, and it's outweighed by confusion of the issues, prejudicial effect, and the like. I mean, it's just overkill. And all these videos, I'm not going to say all of them, but a great number of these videos have absolutely nothing to do with the issues involved in this case. And this is why this case is taking so long.
Well, I mean, I think it is probative of the assertion that YSL is a gang willing to commit criminal acts. Now, how many? So this is Zachary, Buck, and who is the other? Who is the third person? Do we know?
Not at the top of my head, but I want to.
Buck is asserted to be an unindicted co-conspirator.
Yes, and to be clear, Buck has not only has his name come up multiple times, he has been in video. He is his voice was played over a jail call. He recorded one of the videos with Trontavia Stevens and Mr. Williams. So yes, these two are YSL associates members. And also, just as to the point that Mr. Sharp made about the number of videos, the constant cross-examination and sort of rebuttal against this idea that it shows an association, and the nature of the gang is that it's promotional, it's music, it's art, it's something that's not related to criminal street gang activity. So our position on that is unless there's this stipulation regarding that, which we assert that it's relevant to prove, that every time that they argue that a particular video is promotional or it shouldn't be taken literally, they are creating the need for the state to show the jury evidence otherwise.
Okay. Do we have a video similar to this one in already?
No.
Do we want to dispute that and point me to what is?
When you say similar, I mean, the state played.
I mean, not like a music video, but
the state played. I believe twice they actually played it. About 13-minute video of young men talking about YSL and slime in a parking lot outside apartments.
Are they pointing guns at the camera while threatening to do things in the name of YSL?
I'm being told that guns were pointed in that video.
And is it I don't mean a music video.
No, it's not a music video. It's a video of.
And who are the people?
It was Walter. It was Trontavia Stevens, Lil D, Mr. Williams, Walter Murphy.
But not Buck or Zachary?
No, Shamar.
Lil D, what was that? Okay, so Zachary.
It was Lil D and Shamar.
Being told was in it. Buck was not in it. I don't know what is important about Buck.
All right. If y'all
Shamar did it.
want to tell me exactly what.
Hey, yo, somebody told Shamar said that, y'all. I'm telling on Shamar, man. Hey, DeAndre told Shamar, say he did it. Straight up. That's who we going to blame it on, cuz. If they going to tell on somebody, they need to tell on Shamar.
Exhibit number that is, or give me that to look at. But my inclination is that this sounds different enough and not cumulative. So I can look at it and, I may change my mind, but at this point I'm overruling the 401 and 403 objections.
We'll get you that exhibit number. 15 is my client's undated Instagram post.
Why so Shamar is crazy.
Post showing a picture of
Shamar King Slime.
of Mr. Zachary. I believe that's Mr. Zachary, although it doesn't quite look like him. I believe that's him. And he's standing next to a platter of pastries.
So I think that's a relevant subjection.
cumulative because the association has been shown.
Okay, what does the state say about that?
Judge, we don't have to use this initially. We believe that it could rebut a particular line of cross-examination, but right now we won't use it in our direct of Mr. Zachary.
Okay, so there may be some cross-examination about whether they went to a bakery one day, and then this might be relevant. Otherwise, they're not going to use it.
And Your Honor,
I'm kidding. I mean, it may be relevant to something else, but who knows? I don't know.
So it's Mr. Stillwell's post
Right.
of Mr. Zachary, and his commentary about Mr. Zachary is what we were looking at. That was most relevant.
He's commenting Mike dripping, so he's commenting on his clothes.
He's dripping in blood. There's a red jacket that he has on, and that jacket, our argument is that that's what he is referring to.
Okay, well, at this point in time, we're not going to be using that one.
Okay.
What's next?
16 is fine, no objection.
Okay.
Yes. 17 is fine, no objection. 18, 401, 403, the association with my client has already been shown. Not sure, Your Honor, just so you know, that is Mr. Zachary and Mr. Stillwell seated behind a bottle of liquor with large amount of cash on them.
So, Judge, this is part of our indictment, talks about the purpose, and I'm going to just read the language. Obtaining money as associates of Young Slime Life, the defendants conspired to associate together for the purpose with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity.
Cap? No, they didn't. They ain't got no property or no money. Did she just say property and money? I know that lady ain't say no land and no moolah. I know she ain't say that boys was acquiring land and moolah. New errors. Yeah, man. Yeah, man.
Including robbery, theft, and unlawful sale of and distribution of drugs.
Mm-hmm.
This is Mr. Zachary posting large sums of money with Mr. Stillwell and asserting their unity. One thing about my brew, again, the B replacing the C, we all eating. So he's talking about,
Yeah, we're rolling in the dough. We're doing well. Do we
What? She just paraphrased that like that?
have other things that already showed us that are similar?
when you say similar.
No, I don't actually think there was a cumulative argument on this one. It was relevance in 403.
Dudes in poverty showing money on phones does not mean they rolling in dough. That's cap. Most of these people are actually the opposite. They ain't really having their way. That's why they showing money on phones. You got money all the time. You worried about people knowing you got money. Not flaunting it. Straight up. Straight up.
Overruled. What's next?
Number 19 is
And who all do we have depicted in this photograph?
Your Honor, we believe that this is Mr. Zachary, Mr. Nichols, and the third person we're not certain about.
All right, this is showing Zachary and Nichols in the same kind of YSL posts with guns.
Showing, yes.
Okay.
Your Honor, 403.
So
Highly prejudicial outweighs the probative value.
it does not. Overruled. What's next?
Yo, Atlanta is the home of prop money. Bro. Yo, you know how many people got fake money given to the strip clubs, first off. Then once you add in the music videos and a lot of people shooting videos, prop money everywhere. Straight like that. Anybody that call themselves a an entry-level movie director or, anybody that got props for any of this type stuff, they got about $100K. I done had about a $200K, $250,000 worth of that shit. It's already bundled up. Some of it has got two sides. If you bust it out the pack, it actually is real bills. They stiff as a bond, John, and they say motion picture on one side, but you got to look real close. If you don't know, that thing real. People come in my studio. I'm talking about more than 100 people walked in my studio and grabbed a bundle of money sitting on my desk. I ain't exaggerating. More than 100 people. That first time coming to the studio, I had the bundle sitting on my desk, so it looked like it really was the 10 rack sitting right there, all Huns. Bundled up, though, with the paper on it. You know how many people grabbed it? I swear. Don't know me from Adam or Eve would reach over me and say, damn, bro, let me see. This ain't real. And grab it, though, off the desk. Swear to God. So, and some people, they sell it by duffel bags. Like, if you really want, you can go online and buy it by the whole duffel bag filled. For real.
What do you, I don't have a problem with.
You can get bundles of money. You can get it rubber band up, or you can get it paper band. You know how you want it. What you want, twans? What you want, fives, ones? How you want it? You want foreign?
Your Honor, that is who is.
Okay.
That is who is shown in this photograph.
Okay.
You want one-sided fake money or double-sided?
Number 22 is Jeffery Williams.
You want the bundles to be stiff to where as though you can't even flap them. They just one bundle. That's cheaper. You want to be able to flip through it a little bit. That costs a little more. You want to be able to take the bills out the bundle. That costs a little more. Real rap.
I don't have an objection.
Okay.
Yeah, it's still what it is. And number 23 is another picture of Mr. Zachary and my client, Mr. Stillwell, at some sort of arcade, sticking up their middle fingers. I would object to that. Relevance 403.
All right.
Cumulative.
6 days.
Go ahead. What's the state's response?
6 days after the murder of Donovan Thomas, this post is made. We gangster in every city we go.
All right. And this is 23, right?
23. Oh,
20. Which
yes,
one is
number
this?
23.
20, yeah, right. Well, I just clicked out of it. And the main objection is 403 on this one.
In relevance, and Your Honor, while we're at it, the state said, brought up the caption. I don't know why that caption would be displayed. That's the words of Lil D. Sure, he's testifying. I guess potentially that could be impeachment, but I don't know why his out-of-court social media declaration would automatically be admissible.
It is the assertion, the public assertion, the fact that it is made publicly to display their dominance. This is 6 days again after Donovan Thomas. We believe that they went out of town into another city following the murder of Donovan Thomas, and an assertion that we are gangster in every city that we go. The fact that you made the post, that you put yourself out there with another YSL member in itself is evidence beyond the words that are spoken.
That's super cap. Bro, this is bad, bro. This is bad. That they even going to this level of reach. Golly, bro. They like Sylvester Stallone cliffhanger, bro. They better not look down. Straight up. Reach. Manute Bowl.
What rule of evidence would allow an out-of-court declaration by someone who's is not a statement of a defendant or a statement of a party opponent? I don't know what rule of evidence they keep saying because he's saying they're gangsters.
I assume, is he alleged to be an unindicted co-conspirator? I would think that would be the rule of evidence.
I don't know how this would be deemed in furtherance of a conspiracy.
Because it shows, number one, it asserts their dominance. It shows, it asserts their cohesiveness. We are gangster in every city we go. It promotes their pull up the indictment.
Dang, gang, what?
It preserves, enhances, and protects their reputation, power, and territory by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise.
Lady, they fake bloods in their own city. How they gonna be real when they leave? This ain't that, lady. This ain't that.
And a willingness to engage in violence on his behalf. It is literally a line that I just read is literally a line from the indictment. And so this post itself is proof of that assertion and allegation in our indictment.
All right, I'm gonna hold my ruling on that, and we'll see what else we've got.
Your Honor?
Yes.
All these that we're going through, there has to be some sort of foundation. I mean, if Mr. Zachary says, yes, I posted something like that, then that would be bolstering, right? We're cumulative. If he says, yeah, I posted that, and this is the reason why, just because it's in the indictment does not make that assertion credible. So the witness has to testify to all this before it just comes in as an exhibit. Am I wrong?
Well,
I mean,
it has
that's
to be
what I would be
introduced
objecting.
in some form or fashion.
It has to be introduced. That part we agree, but not that it's not permissible or admissible as an item of evidence just because he says I did post it.
Right. Okay, so I'll withhold ruling on that one. What's next?
That's all the social media
Okay.
folder.
All right, so
Oh, yes.
Hey,
And Your Honor,
yes.
the exhibit
Yo, these lawyers need to be working on trying to pass a rule whereas though social media bolstering from dudes that's trying to make a music career should not be able to be used as evidence in court. Straight up. Because the amount of fake people bluffing online to try to, present an image is overwhelming in reality, the people that's really thugging. So, like, these people that's claiming to be lawyers online, why they not working on nothing like that if they see these types of problems? Because they sitting back just letting law be law when they know it's lopsided, but they want to monetize off of dudes acting like they really rocking. That's just odd to me.
number for that other video that's already been played is states 60 WA.
Okay. If
Talking about these
yes,
other lawyer
y'all have it
YouTubes
handy and
meeting
can
up.
just shoot it to Ms. Bursfield, and I don't have to go through the former court reporter to find it, that would be great. If not, I'll try it the other way. All right, so let's look and see what else is in the folder for Mr. Zachary. Y'all can see the same things that I can see. Is there any objection to the other 5 items? I think the last one's one of the interviews. So is there any objection to the other 4 items?
The second to last one.
Yeah, I couldn't open that one
I couldn't
actually.
either.
So can y'all maybe share that one? Do y'all know the one we're talking about?
Is it one of his interviews?
I don't know. It may be. It's 3.95 gigabytes, so maybe. It just seems to be in a format that.
It's an evidence review.
Hey, yo, free thug, vote
Okay,
for
so it's the
Kramer.
other interview. Okay, that's fine. All right, so then objection to the other 3 items.
Free thug, vote for Kramer.
Anybody?
I'm sorry.
Free thug, November 4th, vote for Kramer. Free thug, November 4th, vote for Kramer.
Items.
Okay, and you're speaking, I guess, and everybody else's silence is assent here. Okay. All right, so that's Mr. Zachary. Should we look at, is Mr. Sledge, let's look at Mr. Sledge. He's going to be either right before or right after Mr. Zachary. Okay, let's see what's in his folder. All right, we've got a jail call folder, a social media folder, a tattoos folder, and then some other items. Have we already dealt with any jail calls for him?
Your Honor, that's the one that the state said they would only play for impeachment.
Okay, and that's the only thing in that. Yeah, okay. So that's all right. And then how about social media? Do we need to go through his social media? I would suspect.
Yes, Your Honor.
Okay.
Excuse me, Your Honor.
Yes.
Could I have 5 minutes before we begin that process?
Yes.
Thank you.
If anybody else needs to use the restroom, all right, let's take a quick convenience break.
Yo, so Billboard, Atlanta Republican DA nominee Courtney Kramer vows to shut down Young Thug YSL trial if elected. If elected. Maybe the YSL RICO trial of Young Thug and company isn't going to last indefinitely after all. Well, if the Republican District Attorney nominee Courtney Kramer has her way, it certainly won't. Billboard reported that Kramer has vowed to shut down the ongoing YSL RICO trial if she is elected. Kramer isn't playing, or maybe she's just playing politics. She criticized the current Fulton County District Attorney, Fonnie Willie, accusing her of using the case to gain personal fame. In a statement released by her campaign on August 16th, Kramer expressed her highly concerned and disappointed views on the trial, citing what she believes to be a lack of prosecutorial oversight. But by using the trial in her statements while running for elected office, isn't Kramer doing just that? Get this. Kramer argues that the trial, which began in November 2023 and involves Young Thug and his co-defendants, has been over-prosecuted, quote unquote, and is a complete and utter waste of the court's time, she said. She claims that the case has drained endless amounts of taxpayers' dollars without justification. Kramer promised, if I am elected as the district attorney next of Fulton County, I promise to end this prosecution immediately. Yeah. Kramer actually challenged her opponent, Fonnie Willis, to do the right thing by ending the prosecution and releasing the accused, many of whom are being held without bond. We all know the YSL RICO case has faced numerous challenges, including the recusal of Judge Shakur L. Ingram in July due to potential impartiality concerns. Judge Ingram had a prior connection to a former deputy involved in the case, which led to her stepping down to maintain public confidence in the trial's fairness. It's a mess, but Kramer isn't the DA, and maybe Willis knows exactly what she's doing. Whether a jury believes her case against Young Thug and YSL remains to be seen. Let me know in the comments what you think about Young Thug's sister being a co-conspirator. It's just like ghost question, or, like this mystery behind everything. Some people alluding, woo, woo, woo. Some people saying, lot, woo, woo, woo. But let me know in the comments what y'all think about that. They keep saying co-conspirator, but what does that really mean?
Making a public proclamation displaying their belief towards snitching. You have not only Mr. Sledge making that lie to their mama and lie to their sister, getting to court and tell the guys on the street. You have Mr. Williams, who posted a similar video with Mr. Sledge apparently in the background.
Films.
Mumbling, saying, sort of signing on to whatever it was that Mr. Williams was saying at the time. We would argue this right here is more of that. This is who we are. We don't snitch. You let the police do what they're supposed to do, but you don't tell on your friends. Yeah. And under the circumstances of this trial, especially considering some of the testimony the jury has heard, we believe that this particular type of posting, public posting, is very relevant to explain some of what the jury has seen.
Okay.
Two things, Your Honor.
Yes.
First, the state has said they have a video of Mr. Williams saying things about snitching and Mr. Sledge saying things about snitching. So this is cumulative. Also, the state keeps saying they feel this, they're saying this. Mr. Sledge
Mm-hmm.
owns and operates presumably his own Instagram account. At no point does he make any reference to anyone involved in this case. At no point is he saying he's speaking for YSL. At no point is he hashtagging YSL or at YSL, anything. He's making a comment as an individual on his individual page, and he's really sharing a meme, but I don't know why that's relevant, and it's certainly cumulative when the state just said they have other people. They have him actually giving a statement, and they have Mr. Williams giving a statement. That's already in evidence.
All right.
This particular assertion, it doesn't just say no snitching. It says you're about to get 20 years for a crime your best friend did last night. So the fact that Mr. Williams has made an assertion that is very similar in nature to the one that Mr. Sledge has made, and then the fact that this particular posting references not just telling on someone, but you're about to take the heat for something your friends did. It's displaying yet another message to the public about YSL and we would argue, their willingness to stick together and stand on, their loyalty towards one another. The argument, I don't know that it's so much necessary to say that it's, it would be our argument that he is asserting the sensibility, the way that YSL operates. That's what we would be doing. It's proof. We would argue it's our evidence of the way that YSL sort of.
All right, I'm going to
promotes
sustain
itself.
that objection on 403 grounds. What's next?
413. Why?
Yo, so let me know what you think about this clip right here. So Weinstein, Yak Gotti lawyer gonna claim that Yak is like his wife. Yeah, I know, right?
It's not,
It doesn't add anything to that.
but it's not the same. He's like my wife, Your Honor. He buys the same style coat, but
That's pretty good, Weinstein. That was a pretty good joke. That was like Seinfeld level humor right there. That boy Holly, he's like my wife.
it's not the same.
Whether it's the same code or of his alibi. And anything else before I exclude this one? No. Okay, moving on. That one's out.
He's like my wife.
23, Your Honor.
Which is going to start with, Your Honor, involved YSL.
I'm sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't
The
understand.
Bussy stabbing. I wonder, is he on the witness list? That name sound familiar. So they poked up a dude named Bussy.
What you said.
Understood. The victim in the January 31st stabbing, his name
Okay.
is Harold
All
Bussy.
right. Bussy, okay.
Harold Bussy.
So that stabbing involved several YSL gang members stabbing an inmate at the Fulton County Jail who was alleged to have messed with Rodelius Ryan's commissary. It involved
Lil Rod was getting extorted. Now, this can go down different ways. Sometimes dudes are sneak and steal something where they being real super petty, or they can bogart you, meaning they just bullied you, like literally took it and looked at you like, what you gonna do? You better not say nothing or I'm gonna take everything. Or they might have took everything and really say, little man, next time you get some more, you better bring it to me. So like, who knows how they try to take his commissary. But yeah, y'all,
among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodelius Ryan. They all, in concert, held down this person and stabbed him repeatedly.
Whoa.
All to protect and to vindicate something he had done to one of their fellow YSL gang members. It's the way that I see it. So that it's seems just, it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay.
What territory? His food?
With respect to
Man.
the law, we would cite Johnson versus the State of Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is 491 to 492.
Man.
In support of it. Okay. With respect to the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distribution, drug use, drug possessions.
What?
And while in court on trial, they are passing Percocets.
Oh my God. Get her out of here.
How stupid are these politicians to allow this to happen? Good morning. And yes.
Bro. Man, they fumbling.
Another. And we argue 1 to the alleged leader of YSL while in.
Yo, leaders get hordes of drugs brung to them easily, tucked up in body cavities. You don't need to do no over the shoulder handoffs in front of a camera that's being televised to thousands of people live right now. Never, boy. Body cavity work getting shipped around, man. Yeah, that thing tucked up, man. It getting shipped, put where it need to be, man. Depending on what facility you at, man. Sometimes we can just raw dog it and do a real on the street style handoff in the yard. Or sometimes you could just get it sent down a TID from allegedly. But like in the court, it's preposterous. Why? I ate that before I even left the block. Like the jail is like a block or something, bro. Niggas crazy. You ain't need to, man. Before we even made it on the bus to go to court, man, I was already What are you talking about, boy? And I had another one on me. What are you talking about when I left out this morning?
Open court. One of the assertions that we make regarding the conspiracy.
One jump. It's crazy. One. They wouldn't even got it, y'all. I'd have ate it before they even grabbed it.
We have contraband in the jail. We have stabbing in the jail of YFN and Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
This not no enterprise. This not no conspiracy, y'all. Don't believe her. It flow from the jail to the street. That's cat. That's cat. You got petty members locked up. That's not even real members. It's not a real gang. You've been reaching. They not real bloods. They in the jail scared. You got most of their members sitting on PC waiting to tell. And you want us to believe that this a real gang. Some of the people you alleging to be the closest members to the highest ranking member is telling. So you want us to believe they young boys is official. That's cap, lady. Stop.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
Man, they
And
say
what
Shorty Lisa Leslie out there. Yeah, Quanty Cash, she the reach goddess. Yeah, she Lisa Leslie, man. Hell yeah. No, no, no. What's the lady? What's the shorty that just got locked up in Russia, man? She's Shorty. Brittany Griner. Yeah, man. Stop playing. She reaching like Brittany, man.
is, I mean, maybe I need
The
to,
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, "Give it here." Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him, and later Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams. And
that's his work. He already got life. So that ho. All right, look, that's his work, y'all. And he already got life, so he got nothing to lose. So there go my theory why the DA tried to use him to shave something for himself, save himself, and incriminate Thug to try to make Thug look bad on the camera. Just like they was doing by putting Polo on the case when he ain't even had nothing to do with this RICO, but they eventually dropped him off. But they want him in the court acting loony. So I'm going to ask y'all, did the state tell Polo to start acting loony in the trial too? Was that a play too?
Okay.
Tests of those drugs.
All right. What's next?
So marijuana was also, so in Mr. Stillwell's cell, there was on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy pills, contraband.
Yo, I don't even know why men is taking ecstasy pills in jail. Now, let me say something to y'all. I was in jail and seen one before, and the first thing I thought of, whoa, y'all tripping. I'm not taking one of them in here. I'm either going to fight or jump on one of these lady CO's backs. Y'all crazy. I don't know what y'all ready to do with yourself, but it ain't enough freedom in here to be taking one of them. I'm going to keep it real. Straight up. This is not what you want. This thick back, light-skinned African come past me and open his cell while I'm off this jank. I don't know what I might do in here, man. Straight like that. So I don't need no jank in here. Nah, cuz.
A contraband cell phone for him to have gotten.
I really looked at it, dude. Dude offered it to me for free, too, cuz I come in, I just happen to know a couple guys. So I just happen to be in the right spot at the right time, right? So the bird land, soon as it land, the whole move was, soon as it looked like the move was, once it land, they normally just go ahead and just eat them bitches. You understand? So being as though I was right there, I got the offer. Like, yo, you want one? So when I look like, oh, whoa, what, they got them in head? Niggas like, yeah, what you talking about? Like, nigga, you ain't just see it, you feel me? I'm like, oh, hell no, I don't want that right now. Hell no.
Those drugs.
They crazy, cuz.
While he's on trial for.
Yeah, I don't want that.
Okay.
Actions involving narcotics and the enterprise and the sale and distribution of drugs through that enterprise.
Yeah, they crazy, cuz. Now, some of these dudes was messing with COs and all types of stuff. They been in there before me, so they might have had a lick. You feel me? Who knows? But, I ain't, nah, bro. You know what I mean? Let me get some tobacco.
We believe is evidence of the ongoing conspiracy.
Okay.
Another.
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
That Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana on Mr. Ryan. And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the deputy,
a large commotion by
Mr. Ryan. And the deputies found the marijuana attached to, I think, his inner garments.
Okay.
Bro, we talking about usable amounts,
Okay,
though.
we don't know how it got there.
Shorty holler, we don't know how I got there. When it's in the thigh. Okay. Yo, usable amounts though, bro. It's crazy. What are we doing? What are we proving? Because these dudes wanted to get high. And we talking about not a heavy pack. We talking about one run, one night highs. Seriously, bro, this ain't even a bad habit, bro. These boys barely smoking. If this was crack, they wouldn't even be skinny. If this was crack, they wouldn't even be skinny, bro.
I mean, on the Percocet, you've got an alleged gang member providing it, right?
Yes.
So, how about we don't have anything like that with regard to the marijuana?
We don't have provided him with the marijuana, no.
Okay. All right.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one on here.
Okay. I think that the first three that we talked about are, I can see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from, that one, I just don't see that falling within. I mean, it shows, what it shows, that he's in possession of an illegal substance, but it doesn't, I don't think it's intrinsic. So I'm going to rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
I appreciate it too, Shot.
Oh, is that one of his? That's not something.
No. I'm saying you're
That's
keeping
not
it out
anything.
without hearing, but from us. But regarding Mr.
Yeah, hell yeah. Hell yeah. Hell yeah. Hell yeah. Throw that out. See, I don't know how to treat this lady. I don't know how I feel. Like you feel me? I feel like she'll let me smash. But then I feel like she might got a racist dog. I don't know how, it's crazy. So maybe I should take her to the hotel. Just don't go back to the spot. You feel me? It's kind of like 50-50, right?
Stillwells.
Mm-hmm.
Okay. We have an indictment with 100, I believe it's 191, could be 191 over X.
Yeah.
Okay. We also now have a list. At first we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no. It's 53 plus 4, 57 plus 191. That's 248, I believe. 248 uncharged events, or not substantively charged events, in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos. I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cellmate.
Okay.
Damn.
There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL.
Ooh.
There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills.
Yes, I told y'all that ain't got nothing to do with no gang. That's personal use. The judge threw the alley-oop to Shot just now and told him she not rocking with the rod evidence because. So yo took it and ran with it. Yo say, well, if they can't prove that, Rod got that from a YSL member or was going to give it to him, then my client was on the same type of wavelengths. You heard? I like what he did right there.
Were being provided to anyone in YSL. There was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise. Mm-hmm. And without any evidence that somehow this is linked to YSL, this isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario, and it's inextricably intertwined with the evidence for the charged offense. I don't believe that's the case either. So
Well,
I don't know why this
I
is.
understand. Thank
And,
you.
and just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still, but he is charged separately, and that case is pending in full county superior.
Okay, appreciate it. Thank you for bringing my attention to that.
Your Honor?
Yeah.
Ooh,
If I
boot
may get
smoke.
further,
Boot smoke. Boot smoke alert. Yes. She acknowledged. Oh, that's nice. So you mean to tell me that's like the Rod one that I just said that we ain't gonna bring that in? Oh, thanks for telling me that it's similar to that, because I'm about to throw that out too. Oh, hopefully she don't bring that in, because Shot sold it real good. Like, oh, my cut, even if Cuz was hustling, you feel me? He wasn't doing it under the name of YSL for real. Kind of like Rod, had it strapped in his inner thigh. And that ain't had nothing to do with YSL. That was nice.
the one case,
On which?
really regarding all three of them.
Okay.
I'll start specifically with the stabbing as the state did.
Can I rule on this other one first?
Yeah,
Give me
go
just
ahead.
a second.
Which other one?
The one that Mr. Sharp
Oh,
was
yes,
just
yes,
talking
Your
about. Okay.
Go
So
ahead.
the Stillwell had a cellmate. Is there any evidence as to where the drugs came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
Well, two things. So we believe that. I think we have to do body research. We believe that the testimony from the deputies within the jail would establish his ownership of it. But more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills, if we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL member's possession. That is not on here and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay. But
And we know that at least that other one, other YSL member, smuggled the drugs into the jail, or at least into that area, through the courtroom.
Can you prove that those are from the same batch, or those could just be this type of pills that have flooded the drug market of Georgia State in totality? So you mean to tell me because you've seen a certain brand or style, you're saying that they are the only inmates who had that, and the only way they got that in there was one source that happened to be YSL? That's what you're saying right now? It's not like they branded the product under YSL. You saying they had another brand that's flooded on the drug market, and because they're part of the same gang inside the jail and they had the same product, you're saying it came from the same load?
As it was described, it was enough in one. It was a pharmaceutical.
okay. So any evidence that what was in Mr. Stillwell's cell came from that?
Other than it was.
Did you test the batch to see the consistency of the pills to see if they matched? Whoa.
That they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array of
Blue, purple, and...
Sorry, you lose. Sorry. That's not going to work. You're going off a visual? Sorry, lady. No. The whole black market works on visually making pills that look like. So did you test to see if these was even real drugs? Whoa. Oh, y'all ain't know about that? Oh, yeah, game over. Where the test? Was it real drugs? Yeah, buddy. Where the lab test? Where the lab test? Nah.
To use just some colors. Like there were literally at least three different colors and three different shapes of pills. and they were the
Bro.
same 3 different colors and 3 different shapes.
And you can establish that those were YSL related?
Yes, because the when you say those, you're talking about the ones.
So if I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial,
Right.
Are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not
there?
the same pills, the same
Right, the same, shipment or whatever, the same.
that person was in this trial. That person was in this trial during that time.
Okay, but then being in the trial and co-defendants doesn't establish what the assertions are.
No, it's the not similarities, the exactness of the
I'm not asking at this point, assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
maybe the approach with a number of things.
Sure.
There is none, Your Honor. But she round on the back. Ain't no tying, though.
So we can hear what's going on.
I didn't know y'all didn't have them. They're not up here. Yes, you may.
Thank you.
So are y'all satisfied about, our other bench conference was about the location of that other person? Everybody, I just assumed that y'all.
One of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist.
Mhm.
That wouldn't be relevant either. What they're indicted for is what they're on trial for. So here we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor.
Oh, yeah? That's a violation of due process for them to bring up evidence that the grand jury didn't go over before they indicted? That's a violation of what? For real? That's different. I ain't know that. Let me know if you understand law. Let me know in the comments about that. Oh, yo, so the judge just threw, I don't know who she threw under the bus, but she just kind of took what homegirl just said and G-checked everybody. Listen to this.
That's not our issue right now, but yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at, in the state's original notice, they cited proposition, I believe that was cases have been in gang and conspiracy prosecutions, gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases.
Mhm.
There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these.
Whoa. Now, I'm going to tell y'all what the state's argument to this is. I told y'all. See, they not floating one motive. They throwing a lot of different things up in front of the jury and hoping the jury just grasps one. I told y'all that. So that's why they're trying to just keep throwing all types of evidence instead of it being the initial evidence they staged to lock their case in. Normally, when somebody got a case, they got their evidence. They don't need to include nothing new. What? For what? We got our case. We're not going to mess this case up that we locked into. You understand what I'm saying? But here we have it. They don't have order, structure. They moving different witnesses around. They done lost witnesses. They ain't got the testimonies they was expecting. All of these types of things. So shorty on point. But yeah, I mean, it's getting sticky, y'all.
Things hadn't even happened yet. So it's not possible that they could be essential.
Let me ask you this. If, for instance, and this is entirely a hypothetical, but if this group got together and stabbed this, whatever his name is, Bussy, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case. Would the argument be different then?
Well, yes, it wouldn't be. They wouldn't be trying to admit it as an intrinsic act. It could be a crime in and of itself.
No, we're not talking about then they get separately indicted. We're talking about they're in the middle of this trial. This happens.
No. That still shouldn't be brought up in this indictment because it would cross past. It didn't go through that original grand jury that read over the indictment. That's what she just said. So if it's a new charge, it wouldn't be able to, it would have to go back in front of the grand jury and then re-indict like they did at the beginning of the trial before the trial started, which means they re-edited the indictment, brought it back out. It went to a grand jury, then it got brought back out. Now that we already in trial, you can't add stuff to it. I think I'm right now, off of strength of what Shorty done said so far. Straight up.
Not obviously set forth in the indictment because it just happened.
It would be 404B and probably fall into a category there, which would make it admissible for a basis which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would...
Meaning it wouldn't be an overt act. It would only be produced as character evidence.
Still make the same argument that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be necessary to complete the story, unless the story wasn't complete at the time of indictment. But that's fundamentally unfair to try them for something which hasn't happened.
Okay.
There you go. Party time. I was right. So if she right, then that means once they get the court date rolling, they can't add to your indictment and try to charge you in this RICO that's current with a crime that happened while we was in court. They can bring it up to try to paint a picture, but they can't use it as an overt act. They're going to have to run us back. They're going to have to do something else about that later. That's what I'm hearing right now.
They're not being tried for it. It's okay.
Based on
all right. Well, I mean, y'all try to find me some more on-point law on both sides, please, if you could. So maybe that'll be my preliminary ruling, subject to revisiting. Okay.
Hey, Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where Mr. Stillwell, where the drugs were found in Mr. Stillwell's cell, there were Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL?
Whoa! 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 Judge just ain't having it today. Judge just ain't having it today. What brand was the shank? What brand? What'd it say? What'd it say right there? Huh? Nah. What you took, it wasn't, what you seen, an inscription on it or something? Golly, y'all. Whoa. Shorty ain't playing today, man. I don't know what happened. Man, that's tough. You found it. It said YSL?
It doesn't. No. Is the shank inscribed YSL? Is the shank inscribed YSL?
There were Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL?
Ugh.
Then it doesn't. It doesn't. No. I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes.
Okay.
Your Honor,
yes.
If I may,
yes.
Before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of Percocet.
Well, hold on, y'all. First off, they can't blame Stillwell for having the shank. That boy done got poked up like 4 times. I could be exaggerating, but I think I'm close, right? And he done got put on, yo got poked up good. You understand? Not a just a light one. He got a good one. You feel me? So look, right? Over the years, he done got it. You understand? So, on this strength, technically, yo got a lawsuit against them. Yeah, how about that? They continuously let this boy get poked up. and you're going to try to charge him for having a weapon that could defend himself possibly from losing his life when y'all done clearly let this boy get lined up when he's supposedly been on some type of protection since 2015, I think, y'all. I mean, I could be wrong, but I could have swore I seen an old clip where his girl say, I don't know how he get poked up in 2000, in the joint. They supposed to have him on protection. Maybe I'm wrong, though.
From Mr. Khalif Adams to Mr. Williams, I would ask that the court at least go and take a look at the video that was referenced by the state. I think it's instructive. I also think that it fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. Well, what I recall and what I know happened, because I was sitting right next to Mr. Williams in the front of the courtroom, is that it was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy, who I was within earshot of, did not say, give it here. Mr. Williams looks at it and puts it down on the table. And that's it. Okay. At which point, another deputy sees Mr. Adams and either takes him, I don't remember if they took him in the back or brought him back here. Okay. He was searched in the back, as I understand it. I think court recessed after that because of those occurrences. But that's how the incident actually occurred.
Okay. Can y'all send me that video?
Yes, and the deputy, the lieutenant, would also be a witness to what I'm saying.
All right. Well, I would imagine the video shows what happened. So.
Man, that deputy ain't gonna be able to withstand Adams cross-examining him. She better not bring that deputy in the middle of this, y'all. I'm just gonna say this right now. She better not bring that deputy up here, cuz. Yo, this boy gonna chop. Yo, he said he was sitting 2 feet. He not playing with y'all. You better not bring him involved, man. Adams, man, I don't know, man. She thought she bringing innocent people involved. Bro, I don't think she should bring him, man. Maybe I'm wrong.
It does indeed speak.
All right. Well, we'll come back to those two. All right, so that takes care of the allegedly intrinsic, but according to the defense, can't be intrinsic because they happen later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
I can, but with intrinsic acts, that's not part of the analysis.
Yes, 403 is the analysis.
Well, 403...
Which includes the prosecutorial need, waste of time, prejudice, substantial prejudice outweighs any appropriate value. But to me, this is a big case. It's been going on a long time. And now intrinsic acts. So, yes, I don't know how much the state needs to prove that Mr. Williams was knowingly or unknowingly given an alleged item. I'm not so sure the crime lab came back, but I can't answer for that.
Right.
The crime lab came back?
Crime lab.
Sure. I don't know. I don't remember.
Okay. All right. So we now
ain't got
have
no
a
crime lab. It ain't no drug. Straight. Remember that, y'all. No crime lab report. That ain't drugs. Straight like that. What drugs? You got to prove that was drugs. That's not drugs. Man, that's not drugs.
3 argument or objection.
Telling y'all.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act. And looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
them having a trafficking amount of drugs, right?
At least one. So we would argue that it in no way can be viewed as substantially more prejudicial than probative, and it's intrinsic. but we're pulling up the video too.
Well, I mean, I guess is it intrinsic is yet to be determined based on the time period, but.
Your Honor, this is not really my argument, but I have got to weigh in here on this issue. Yeah, thank you. I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative. As Mr. Steele said, you also have undue delay and waste of time, and those are factors as well that I'm not surprised that the state ignores because they seem to have no concern for delay.
Yo, he just spit on Quay. Quay was wiping his face. Yo just jumped out the gate and spit on Quay.
Delay and waste of time, and those are factors as well that I'm not surprised.
Yo spit on the other side of Quay's face. Golly, that was crazy. How you do that?
The state ignores because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
All right, thank you. Okay, well, I will give y'all a couple of days to, if you can find more on point law, provide that. And if not, I'll just have to go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. I may not get to that, but okay. So that's those.
Ms. Love said, quote, our gang experts have testified to B replacing C. So there's a situation there where their gang experts have testified to the same thing multiple times. There's B replacing C. It's constant, Your Honor. And there's absolutely no reason that they should get to run this courtroom. Now, I'm not asking to run it. I'm asking you to run it.
I'm running it.
Okay? And you have the ability to put a time clock on the state. We're way past the time. I'm just going to finish real quick. We're way past the amount of time that we have told the jurors that they will be here. And that is a factor that you can consider. We told the jurors, now I remember 6 months. Other people have said we told the jurors 6 to 9 months. We're going to far exceed that. There's any number of reasons, and they're outlined in the motion. If you don't want me to argue it, I won't argue it, that we can put a limit on the state, or you can put a limit on the state.
Okay, I understand what is set forth in your motion. I understand the law. I understand what my powers are as the judge presiding over this case. I understand that cumulative evidence is unnecessary and maybe undue delay and a waste of time. I also understand that the state has a right to present its case and that they don't have to be limited to just one witness per, count in the indictment. They have rights to. So I appreciate what you put forth there. I agree with it. I mean, it is granted. Okay. I will not permit there to be excessive, repetitive, witness after witness saying the same thing, exhibit after exhibit showing the same thing.
Well, the relief I requested was to put a specific time, whether it be days or hours or however you want to do it. So if that's granted, I am thrilled.
Well, I'm not sure that I know at this stage, given that we have only not yet gotten through one incredibly long and somewhat painful witness testimony, what that time limit might be. I don't anticipate most of the other witnesses to be as long on the stand as this particular witness has been. And maybe I can get, maybe let's just ask the state right now, like time-wise, do y'all expect any of your other witnesses to take as long as Mr. Copeland has thus far taken?
No, we didn't expect him to take them.
But, Your Honor, this is not the only witness that is
I cannot do anything about what happened before I was the judge.
I appreciate that.
I just can't.
And I'm not asking you to. All I'm saying is that the state's saying that they don't expect other witnesses to take this long. There have been repeated witnesses that have taken weeks.
Okay. Well.
Let
me drill down a little bit more. Okay. So are there any other witnesses that are going to have video interviews that are anywhere as near as this witness?
No. And for any witnesses that have taken more than a few days, there have been breaks, there have been pauses that have caused us to have to take that witness over a period of time longer than we ever anticipated.
And I hope we don't continue to have sound issues, but, nobody can do anything about that, although I'm trying to at least get us a reasonable backup, which should have already been in place anyway. But, all right, so I'm going to need an answer as to why there needs to be any other gang expert at all in some amount of detail. And y'all have the witness list, Just like, I mean, you have the state's witness list. So if there's somebody else like the two extra gang experts that you all looking at the list and knowing the case backwards and forwards think, the person who's going to say this, somebody else already testified to all of these same things, then you'll bring it to my attention and we can go through and get answers as to whether those people or those witnesses or those exhibits are cumulative. But I can't know at this point in time. I haven't been in this case long enough yet to see what's reasonable for, a witness to take.
Okay. So I'll be back in a few weeks asking again.
Okay. All right. So I think there aren't any other short things. I'm happy to stay here another hour if y'all would like to.
All right, y'all. So basically, we went through all the motions today. Those was the most interested parts of the day, to be honest. It wasn't a lot to go over, but some interesting points was brought up by Rod Lawyer, Shart, Steele, and Weinstein. So they're going to get some things situated this week, and I think we should be on a roll after this. I think for the most part, she ready to make sure they got all the evidence kind of in order. So we should get on a nice roll of witnesses once the jury do get back. So let me know in the comments what y'all think about what happened today and if I missed anything. Nah, I don't think the wiretap's going to tilt nothing. It could be some things on that, but them boys was too grown by the time they made it to the wiretap. Some dudes might be talking loose, but I don't think it's going to link to Thug. Let me say that. I don't think nothing on the wiretaps they're going to be mentioning Holmes' name like that, to incriminate him. They might speak and be talking too much, but I don't think they're going to be blatantly just pointing the finger at Thug. By then, he's so far removed, he ain't involved in nothing, and they damn sure ain't going, I don't think he had nobody doing nothing for him that he going to be speaking about on no wiretaps. So I'm not really too worried about him. I can't hard stamp it. I don't know for sure, but I don't feel worried about the wiretaps. That's me personally.